Good morning, ladies and gentlemen, and welcome to the Gallagher Law Firm. I am Keith Gallagher, the principal of the Gallagher Law Firm. Just started my 42nd year of practice as a plaintiff's personal injury attorney here in Las Vegas. Now, in our last session, we talked a little bit about the TAM decision, and that's the decision that was recently entered by our Nevada Supreme Court, which upheld Nevada's statutory medical malpractice scheme. And I say scheme because that, from a plaintiff's practitioner standpoint, that's probably what we would call it. For those of you who have been in the state for any length of time, you will remember that not too long ago, the medical community and their insurance carriers came to the public and basically convinced everyone that if the medical malpractice premiums on their policies were not lowered, they could not afford to practice medicine, therefore they would all have to leave the state. That, of course, panicked our populace, and as a result, there became a groundswell of support for legislation, which was enacted by our Nevada legislature roughly 15 years ago. And what that legislation did is it limited the caps on what we call non-economic damages. Now, let me tell you a little bit about what non-economic damages are. If a person is injured as a result of someone's medical negligence, they of course have the right to bring a claim, a lawsuit, against that individual, the person who caused the injury. Now, these injuries can often be catastrophic. For example, a doctor operates on the wrong leg, operates on the wrong area of the back. When he performs an operation that removes the foot, he removes the wrong foot. These things happen, unfortunately, with some frequency, not only in Nevada, but throughout the world. Well, obviously, the person who's been injured has been injured horrifically, maybe disfigured, maybe crippled, maybe rendered a paraplegic, rendered a quadriplegic. Well, in the past, before this type of legislation was passed, the recovery of those non-economic harms and losses was not limited at all by the legislature. If a jury heard the case and decided the case was worth $20 million in non-economic damages, well, that was a decision, and the insurance carrier and/or the physician paid whatever the jury awarded. Well, the legislature took that away from the juries now, and they've said in the future, $350,000 is the limit on non-economic damages, no matter how horrifically the plaintiff is injured or how much his family or her family has suffered as a result of the injury. And that, unfortunately, was upheld recently by our Nevada Supreme Court in the TAM decision, which we have previously discussed.